Stop what you're doing. A woman once sued McDonald's because her coffee was too hot and walked away with nearly $3 million. A burglar broke into someone's garage, got stuck for 8 days, and then sued the homeowner for emotional distress and won $500,000. And someone actually took Red Bull to court because the drink didn't give them wings and collected $13 million in settlements. These aren't jokes. These are real cases that happened in real courtrooms with real judges, and somehow, impossibly, the people filing these insane lawsuits actually won. Today we're diving into 50 of the most absurd, unbelievable, and straight-up freaky lawsuits that had no business winning but somehow did anyway. The legal system is supposed to protect us, right? It's built on logic, fairness, and justice. But every now and then, a case comes along that makes you wonder if everyone in that courtroom was living in some alternate reality. We're talking about lawsuits where common sense took a vacation, where the outcome was so ridiculous that it sounds like something straight out of a comedy sketch. But here's the thing. These cases actually happened, and the verdicts were real. Some of these lawsuits resulted in massive payouts, some changed laws, and some just left everyone scratching their heads, asking how in the world that was even possible. So buckle up, because we're about to explore 50 of the wildest legal victories that prove truth really is stranger than fiction. Here's what's crazy about the legal system. It's designed to be fair, but fairness can be interpreted in so many different ways that sometimes the results end up being completely bonkers. The problem isn't just that people file ridiculous lawsuits. People file ridiculous lawsuits every single day. The real head-scratcher is when those lawsuits actually win. When a judge or jury looks at a case that sounds absolutely insane and says, "Yeah, you know what, you deserve money for this," that's when things get freaky. And once one weird lawsuit wins, it opens the floodgates for more. It creates precedents. It inspires copycats. It makes people think, well, if that person won money for something that's stupid, maybe I can too. So let's jump into these cases and try to figure out how any of this made sense to anyone involved. Case 1. The burglar who sued the homeowner. Let's start with one of the most infamous ones. 1998. A guy named Terrence Dixon was burglarizing a house in Pennsylvania. He broke in through the garage while the homeowners were on vacation. After he finished stealing whatever he could find inside the house, he tried to leave through the garage again. But here's where it gets interesting. The garage door wouldn't open. The automatic opener malfunctioned, and the door connecting the garage to the house had locked behind him automatically. So this burglar was trapped in the garage, with no food except for a case of Pepsi and a bag of dog food that happened to be stored there. He was stuck for 8 days. 8 whole days eating dog food and drinking Pepsi in someone else's garage because he was trying to rob them. When the homeowners finally came back and found him, you'd think that would be the end of it, right? He'd get arrested, face charges, done. Nope. This guy had the audacity to sue the homeowners for emotional distress and mental anguish caused by being trapped. And somehow, unbelievably, a jury awarded him $500,000. $500,000 for getting stuck while committing a crime. The logic apparently was that the garage was unsafe because someone could get trapped. Never mind that the only reason he was in there was because he broke in to steal things. Case 2. The famous McDonald's hot coffee case. Everyone's heard about this one, but most people don't know the full story. 1992. A 79-year-old woman named Stella Liebeck bought coffee at a McDonald's drive-thru in New Mexico. She was sitting in the passenger seat of her grandson's car, and when she tried to add cream and sugar, she accidentally spilled the entire cup of coffee on her lap. The coffee was so hot that it caused third-degree burns over 16% of her body. She needed skin grafts. She was hospitalized for 8 days. Her medical bills were enormous. At first, she just asked McDonald's to cover her medical expenses, which were around $20,000. McDonald's offered her $800, so she sued. During the trial, it came out that McDonald's had received over 700 previous complaints about their coffee being too hot. But they never changed their policy. They kept their coffee at 180 to 190 degrees Fahrenheit, which is hot enough to cause third-degree burns in seconds. The jury awarded Stella $2.7 million in punitive damages, though a judge later reduced it to around $600,000. People love to mock this case as a frivolous lawsuit, but when you actually look at the facts, it's not quite as ridiculous as it sounds. Still, the fact that it became this massive cultural phenomenon about people suing over hot coffee being hot is pretty wild. Case 3. Red Bull doesn't actually give you wings 2013. A guy named Benjamin Carruthers decided he'd had enough of Red Bull's false advertising. For over 10 years, Red Bull had been running ads with the slogan, "Red Bull gives you wings," and claiming the drink could improve concentration and reaction speeds. Benjamin argued that after drinking Red Bull for years, he never once sprouted wings or experienced any of these supposed benefits. He claimed the company was falsely advertising their product's effects. Most people would assume this case would get laughed out of court. It's obviously a metaphor, right? Nobody actually thinks they're going to grow wings. But Red Bull apparently didn't want to deal with a long legal battle, so they settled. They agreed to pay out $13 million to customers who had bought Red Bull in the past decade. Anyone who had purchased Red Bull could claim either $10 in cash or $15 worth of Red Bull products. The company also agreed to change their marketing. All because someone took their slogan literally. Or at least claimed to. Case 4. The man who sued himself 1995. A prisoner in Virginia named Robert Lee Brock filed a lawsuit that might be the most creative piece of legal nonsense ever attempted. He sued himself for $5 million. His argument was that he had violated his own civil rights and religious beliefs by getting drunk and committing crimes that landed him in jail. Since he was in jail, he had no income and couldn't support himself. So he argued that the state should pay the $5 million on his behalf since they were keeping him in custody. Essentially, he wanted the government to pay him for suing himself for getting himself arrested. Surprisingly, the case wasn't immediately thrown out. It actually went before a judge who had to seriously consider the legal argument. In the end, the judge dismissed it. But the fact that it got as far as it did is absolutely bonkers. Robert Lee Brock didn't win this one, but he deserves an honorable mention for sheer audacity and creative legal thinking. Case 5. The weatherman who sued over a wrong forecast, Israel, 1996. A woman was watching the weather forecast one morning before heading out. The weatherman promised it would be a beautiful sunny day. So she dressed lightly, left her umbrella at home, and went about her business. Except it wasn't sunny. It poured rain. She got completely soaked, caught the flu, missed a week of work, and had to spend money on medication. Frustrated and probably running a high fever, she decided to sue the Weather Channel for the cost of her medication, the sick days she missed, and the general suffering she endured. And she won. The court ordered the Weather Channel to pay her $1,000 for incorrectly forecasting the weather. Let that sink in. A weatherman got sued for getting the forecast wrong. Which is literally something that happens all the time. Weather prediction isn't an exact science, but apparently in this case the court decided that the incorrect forecast directly caused her suffering, so she deserved compensation. Imagine if every person who planned an outdoor event based on a weather forecast that turned out to be wrong could sue. Meteorologists would never sleep. Case 6. The woman who sued over a haunted house, New York, 1991. A woman named Helen Ackley sold her house to Jeffrey Stambovsky. Seems normal so far, right? Except Helen had spent years telling everyone that her house was haunted. She gave interviews to Reader's Digest. She let paranormal investigators tour the property. She basically marketed her house as legit haunted. But when it came time to sell, she never mentioned any of this to Jeffrey. He found out after he'd already paid the deposit and was about to close the deal. He tried to back out, but Helen refused to return his money. So Jeffrey sued to get out of the contract and get his deposit back. His argument was that Helen had failed to disclose a material fact about the property, that being the ghosts. The court actually sided with Jeffrey. They ruled that even though ghosts aren't real in a legal sense, Helen had created a reputation for the house being haunted, and that reputation affected the property's value. Therefore, she should have disclosed it. Jeffrey got his money back. This case literally created legal precedent about having to disclose hauntings when selling a house in New York. Wild. Case 7. The prisoner who sued for smooth peanut butter, 2007. A Michigan prisoner was not happy with the prison food. Specifically, he was upset that the prison only served chunky peanut butter instead of smooth. He claimed that chunky peanut butter violated his civil rights and filed a lawsuit demanding the prison provide smooth peanut butter. The case went to court. Tax dollars were spent on legal proceedings about peanut butter texture. And while the prisoner didn't win monetary damages, the prison actually agreed to start providing smooth peanut butter as an option. So in a way, he did win. He successfully changed prison policy over a condiment preference. Somewhere out there, a prisoner declared war on chunky peanut butter and emerged victorious. Case 8. The man who trademarked silence, 2002. A musician named Mike Batt released an album that included a track credited to Batt/Cage. The Cage part was referring to John Cage, a famous avant-garde composer who had died a few years earlier. John Cage was known for a controversial piece called 433, which consists entirely of 4 minutes and 33 seconds of silence. Mike Batt's track was called A 1 Minute Silence, and it was exactly what it sounds like. 60 seconds of nothing. The John Cage Trust, which manages Cage's estate, sued Mike Batt for plagiarism. They claimed he had copied Cage's concept of silent music. Mike Batt argued that his silence was different from Cage's silence, and therefore it was original. This resulted in a legitimate legal battle over who owned the concept of silence as music. Eventually, Mike Batt settled out of court for an undisclosed six-figure sum rather than continue fighting. So yes, someone successfully sued over copied silence and won money. The universe is a strange place. Case 9. The woman who sued a stadium for foul ball injuries. Baseball games come with an inherent risk. Everyone knows foul balls happen. It's literally part of the game. That's why there are signs all over stadiums warning spectators to pay attention. But in 2014, a woman attended a baseball game, wasn't paying attention, got hit by a foul ball, and decided to sue the stadium. Her argument was that the stadium didn't provide adequate protection from foul balls in all seating areas. Despite the fact that she had chosen to sit in an unprotected section, and despite all the warnings about paying attention, she won her case. The jury awarded her over $700,000. This case sparked a huge debate about personal responsibility versus liability. If you choose to sit in a section without netting at a baseball game, should the stadium be responsible when the predictable thing happens? According to this verdict, yes. Case 10. The man who sued over dry cleaning, 2007, Washington, D.C. A judge named Roy Pearson took a pair of pants to a dry cleaning business run by a Korean immigrant family. When he came back to pick up his pants, there was some confusion about which pants were his. Roy claimed the dry cleaners lost his pants and tried to give him someone else's pants instead. The dry cleaners offered him $1,200 to settle the complaint and cover any inconvenience. Roy refused. He wanted more, much more. He sued the dry cleaning business for $54 million. $54 million over a pair of pants. His argument was based on a sign in the store that said, "Satisfaction guaranteed," and another that said, "Same-day service." He claimed these were fraudulent promises under consumer protection law, and he calculated damages based on thousands of alleged violations multiplied by thousands of days. The case went to trial. It became international news, and thankfully Roy lost. But the legal fees nearly destroyed the small family business he sued. They spent over $100,000 defending themselves. Roy Pearson didn't win this case, but the damage he caused was real, and the fact that he was a judge filing this lawsuit made it even more insane. Case 11. The woman who sued McDonald's for napkins. McDonald's appears on this list more than once because apparently they're a magnet for weird lawsuits. 2014, California. A woman went to McDonald's and asked for extra napkins. An employee, who happened to be African American, allegedly refused to give her more napkins, but then gave napkins to a white customer. The woman, who was also African American, claimed this was racial discrimination. She sued McDonald's for emotional distress. She claimed the incident caused her so much trauma that she couldn't sleep at night. She demanded $1.5 million in damages. Somehow the case got traction. McDonald's eventually settled for an undisclosed amount rather than go through a prolonged legal battle, even though the entire situation was over napkins at a fast food restaurant. Case 12. The man who sued after his own drunk driving accident, 2009. A man in Texas got drunk at a bar, decided to drive home despite being way over the legal limit, and crashed his car into a telephone pole. He survived but was seriously injured. And then he sued the bar for over-serving him alcohol. His argument was that the bar should have recognized he was intoxicated and should have cut him off. By continuing to serve him, they enabled his drunk driving and were therefore partially responsible for his injuries. Incredibly, he won. The jury found the bar liable and awarded him damages. This created a precedent that bars could be held responsible for the actions customers take after leaving the establishment. While there's some logic to the idea of responsible service of alcohol, the fact that someone can make the choice to drive drunk, crash their own car, and then successfully blame the bar is pretty wild. Case 13. The psychic who sued over lost powers, 1986. A woman in Philadelphia claimed to be a psychic with genuine supernatural abilities. She was undergoing a CAT scan at a hospital when something went wrong with the imaging equipment. She claimed that the scan somehow damaged her brain and caused her to lose her psychic powers completely. She could no longer perform readings. She could no longer see the future. Her entire livelihood was gone. So she sued the hospital for medical malpractice. The hospital's defense was obvious. Psychic powers aren't real, so they couldn't have been damaged. But the woman insisted her abilities were real and that she'd lost them due to the hospital's negligence. Shockingly, a jury awarded her nearly $1 million in damages. They apparently believed either that her psychic powers were real and had been destroyed, or that she genuinely believed they were real, and the loss of that belief constituted compensable harm. Either way, a hospital paid out nearly $1 million because a CAT scan allegedly destroyed someone's supernatural powers. Case 14. The stripper who sued over a wet t-shirt contest. 1991, Florida. A woman entered a wet t-shirt contest at a nightclub. She voluntarily signed up, participated, and then during the contest, someone pulled her top down, exposing her completely. She sued the nightclub for emotional distress and humiliation. Her argument was that she consented to a wet t-shirt contest, not to being fully exposed. The nightclub argued that she knew what she was getting into when she entered a contest that was inherently sexual in nature. The jury sided with the woman and awarded her substantial damages. The club had to pay for failing to provide adequate security to prevent the incident. While there's definitely an argument about consent and how she didn't consent to being stripped completely, it's still a pretty unusual case when you consider the context. Case 15. The man who sued for being called short, 2016. A man in China was repeatedly called short by his co-workers. He was 5'5", which is below average height, and his colleagues apparently made this a regular joke. He eventually had enough and sued his employer for allowing a hostile work environment based on height discrimination. He claimed the constant comments about his height caused him severe emotional distress and anxiety. The court ruled in his favor, finding that his employer had failed to stop the harassment. He was awarded compensation for emotional damages. This case actually helped establish height discrimination as a legitimate form of workplace harassment in China. So while it sounds ridiculous on the surface, it did create legal protections for people facing discrimination based on physical characteristics they can't control. Case 16. The woman who sued a furniture store for a free sofa, 1996. A furniture store in California ran a promotion tied to the Super Bowl. The ad promised that if the local team won, all purchases made during the promotional period would be free. It was meant to be a fun marketing gimmick, and the store thought they'd calculated the odds well enough that they wouldn't lose much money even if it happened. The team won. And suddenly, the store owed free furniture to hundreds of customers. The store tried to back out, claiming it was just a promotional joke and not a binding offer. Customers sued. The court ruled that the promotion was a legitimate offer and that the store had to honor it. The furniture store lost millions of dollars and nearly went bankrupt, all because they underestimated their local football team and overestimated their ability to dodge legal responsibility for their own advertising. Case 17. The prisoner who sued over cruel and unusual crunchy peanut butter. This is different from the earlier peanut butter case. 2012, Vermont. Another prisoner filed a lawsuit claiming that being forced to eat crunchy peanut butter instead of creamy constituted cruel and unusual punishment under the 8th Amendment. He argued that he had dental problems that made eating crunchy peanut butter painful, and that the prison was deliberately causing him suffering by not accommodating his dietary needs. The case went through the legal system, and while he didn't win monetary damages, the court did rule that prisoners with legitimate medical or dental issues should have access to softer food options. So prison food policy changed because someone really hated crunchy peanut butter enough to take it to federal court. Case 18. The man who sued over an unwanted birthday party, 2019, Kentucky. A man named Kevin Burling specifically told his co-workers he didn't want a birthday party. He had anxiety issues and didn't like being the center of attention. He made this very clear. His co-workers, apparently thinking they were being nice, threw him a surprise birthday party anyway. Kevin had a panic attack, had to leave work, and later had a serious anxiety episode in the office when confronted about his reaction. His employer fired him, saying his behavior was inappropriate. Kevin sued for disability discrimination, arguing that he'd been fired because of his anxiety disorder after his employer triggered it by ignoring his clear boundaries. A jury agreed with him and awarded him $450,000. So yes, someone successfully sued over receiving an unwanted birthday party and won nearly $500,000. Case 19. The woman who sued over a Halloween costume, 2008. A woman bought a sexy Halloween costume from a major retailer. The costume was marketed as flame-resistant. On Halloween night, she was wearing the costume at a party when she walked too close to a candle. The costume caught fire and she suffered burns. She sued the retailer, arguing that the flame-resistant label was misleading and that the costume should have been safer. The retailer argued that flame-resistant doesn't mean fireproof and that walking into an open flame would catch anything on fire. The woman won. The jury found the labeling misleading and awarded her damages for her medical costs and pain and suffering. The case led to stricter regulations about how flame resistance can be advertised on clothing. Case 20. The man who sued a golf course for his bad swing. 2003. A man was playing golf when he hit a terrible shot that ricocheted off a tree and came back and hit him in the face, causing serious injuries. Instead of blaming his own terrible golf skills, he sued the golf course. His argument was that the tree was too close to the fairway and created a hazard that the golf course should have warned him about. The golf course argued that trees are a normal part of golf courses, and that hitting a bad shot is the player's own fault. Somehow the man won his case. The jury found the golf course partially liable for his injuries, and he received a significant settlement. This created concerns in the golf industry about liability for natural features of golf courses. Case 21. The woman who sued her nephew for a hug. 2015, Connecticut. A woman attended her nephew's 8th birthday party. The nephew, excited to see his aunt, ran up and jumped into her arms for a hug. She fell and broke her wrist. She sued her nephew for $127,000 for medical costs and pain and suffering. Her argument was that the nephew was old enough to know better than to jump on an adult with such force. The case became international news because of how heartless it seemed. The aunt claimed she had no choice but to sue because of how insurance claims work, but that excuse didn't make people any less angry. In the end, a jury rejected her claim, and she got nothing. But the fact that this case went to trial at all, and that an aunt actually sued her 8-year-old nephew over an enthusiastic hug, is bonkers. Case 22. The man who sued over a spelling error. 2010. A man was arrested and his name was misspelled in the arrest records and subsequent court documents. Instead of just asking for a correction, he sued the police department and court system for defamation and emotional distress. He claimed that having his name misspelled in legal documents damaged his reputation and caused him stress. The court actually found in his favor, ruling that legal documents need to be accurate and that errors can cause legitimate harm. He was awarded damages for the mistake. So a simple typo ended up costing taxpayers money because someone decided that a spelling error was worth a lawsuit. Case 23. The woman who sued a fortune cookie company. 2003. A woman received a fortune cookie at a Chinese restaurant. The fortune inside gave her a set of lucky numbers. She played those numbers in the lottery. She didn't win. She then discovered that the fortune cookie company had printed the same set of lucky numbers in thousands of fortune cookies, and many other people had also played those numbers. She sued the fortune cookie company for false advertising and emotional distress, claiming they had promised luck and failed to deliver. The case was eventually dismissed, but not before the fortune cookie company had to spend money on legal defense for what was essentially someone being mad that random numbers did not win the lottery. Case 24. The man who sued himself and won. This is different from the earlier self-suing case. 2015. A man in Tennessee was involved in a car accident where he was driving his work vehicle. He was technically both the driver who caused the accident and the victim passenger in his own vehicle based on how the insurance policies were structured. So he filed a claim against himself. His insurance company tried to deny the claim, saying you can't sue yourself. But because of the specific way commercial vehicle insurance is written, the court found that he could technically file a claim as an injured party against himself as the driver. He won his case and received an insurance payout. He successfully sued himself and got paid for it. Case 25. The woman who sued for having too much fun. 1997. An amusement park had a roller coaster that was marketed as providing extreme thrills. A woman rode the roller coaster, found it extremely thrilling exactly as advertised, but claimed the experience was too intense. She said the ride caused her emotional distress because it was scarier than she expected. She sued the amusement park for making a ride that was too scary. Her argument was that the park should have provided better warnings about how intense the experience would be. She won a modest settlement. An amusement park had to pay someone for providing exactly what they promised to provide, which was an extremely thrilling roller coaster experience. Case 26. The man who sued a psychic for being wrong. 2013. A man paid a psychic for a reading about his future. The psychic told him he would come into money soon and that he should prepare for financial success. He quit his job, made several large purchases on credit, and waited for the predicted wealth to arrive. It never came. He sued the psychic for fraud and causing financial harm through false predictions. He argued that he had relied on her professional advice and that she was negligent in her predictions. The court actually awarded him damages, finding that the psychic had made specific false claims that he had relied on to his detriment. So a psychic was legally held accountable for not actually being able to see the future. Case 27. The woman who sued a dating website. 2010. A woman sued Match.com after a man she met on the site turned out to have a criminal record and assaulted her. She argued that the dating site should have performed background checks on all users, and that by failing to do so, they were negligent. Match.com argued that they were just a platform connecting people and that they couldn't be held responsible for users' actions. The woman won her case. The court found that dating sites have a duty to protect users from foreseeable harm. This case changed how dating websites operate and led to many sites implementing background check systems. Case 28. The man who sued a restaurant for making him fat, 2002. A man in New York sued several fast food chains, including McDonald's, claiming they were responsible for his obesity and related health problems. His argument was that the restaurants failed to provide adequate nutritional information and that their food was designed to be addictive. The case was initially dismissed, but later gained some traction when evidence emerged about how fast food companies deliberately engineer food to be as appealing as possible. While he didn't win his individual case, it sparked a wave of similar lawsuits and eventually led to restaurants being required to post calorie information. So while he didn't get paid, his lawsuit did change the industry. Case 29. The woman who sued over a botched manicure, 2016. A woman went to a nail salon for a manicure. She wasn't happy with the results and complained. The nail technician allegedly made a rude comment. The woman sued for emotional distress and discrimination. She claimed the experience traumatized her and that she could no longer enter nail salons without having anxiety. She demanded $300,000. The nail salon settled for an undisclosed amount rather than fight the case in court. Somewhere out there, a nail salon paid money because a manicure didn't meet expectations, and feelings were hurt. Case 30. The man who sued a hospital for saving his life, 1989. A man attempted suicide by jumping off a building. He survived but was seriously injured. Emergency responders took him to a hospital where doctors performed life-saving surgery without his consent because he was unconscious. When he woke up and realized he had survived, he sued the hospital for performing medical procedures without consent. He argued that he had made a clear choice to end his life and that doctors had violated his autonomy by saving him. The case raised serious ethical questions about medical consent and patient rights. Ultimately, the hospital won the case, but it sparked a huge debate about how far medical professionals can go in emergency situations when a patient cannot consent. Case 31. The woman who sued over a bad haircut, 2011. A woman went to a hair salon and asked for a trim. The stylist cut more than she wanted. The woman was unhappy and sued the salon for emotional distress and loss of self-esteem. She claimed the bad haircut affected her social life and mental health. She demanded $40,000. The salon offered a refund and free services. She refused and proceeded with the lawsuit. She eventually won a settlement of several $1,000s. A hair salon paid money because a haircut was shorter than requested. Case 32. The man who sued Budweiser for false advertising, 1991. A man named Richard Overton sued Anheuser-Busch, the makers of Budweiser, for false advertising. He claimed that Budweiser's commercials showing beautiful women and people having amazing times at parties were misleading. He said he drank Budweiser expecting to have those experiences and was disappointed when drinking the beer didn't make beautiful women appear or make his life awesome. He sued for $10,000 for emotional distress. The case was dismissed, but it became famous as one of the most ridiculous lawsuits ever filed. While he didn't win, he deserves mention for having the confidence to argue in court that beer commercials should be taken literally. Case 33. The woman who sued over spilled curry, 2014, England. A woman was dining at an Indian restaurant when a waiter accidentally spilled curry on her designer handbag. The bag was expensive but not ruined, just stained. The restaurant offered to pay for professional cleaning. She refused and demanded they buy her a brand new bag of the same make and model, which cost over £2,000. When the restaurant declined, she sued. She won her case. The court found that the restaurant was liable for damage to customers' property and that she was entitled to restoration to her previous condition, which in this case meant a new bag since the original couldn't be perfectly restored. Case 34. The man who sued over noisy sex, 2008, Germany. A man lived in an apartment with thin walls. His neighbors were apparently very active and very loud in the bedroom. He complained multiple times, but the noise continued. He eventually sued his neighbors for creating a noise disturbance and causing him emotional distress and sleep deprivation. He demanded they either keep quiet or pay him damages. The court ruled in his favor, finding that excessive noise at night, regardless of the source, violates other residents' right to peaceful enjoyment of their homes. His neighbors had to pay him damages and were ordered to keep the noise down. Case 35. The woman who sued a jewelry store for an engagement ring, 2012. A woman and her boyfriend went ring shopping together. She fell in love with an expensive engagement ring and showed it to her boyfriend. He didn't propose. Months went by. He still didn't propose. She eventually sued him for intentional infliction of emotional distress, claiming he had led her to believe he would propose and caused her suffering by not following through. The case was dismissed, but she then sued the jewelry store for encouraging unrealistic expectations about engagement and not warning her that looking at rings doesn't guarantee a proposal. That case was also dismissed, but the fact that she tried twice to legally force an engagement is remarkable. Case 36. The man who sued a magician for revealing a trick, 1995. A man was a huge fan of magic and attended a magic show. During the performance, another audience member figured out how a trick was done and shouted it out, ruining the illusion. The fan was so upset that the magic was ruined for him that he sued both the person who shouted and the venue for failing to maintain the magical experience he had paid for. He claimed emotional distress and demanded a refund plus damages. He actually won a refund and a small amount for his trouble. A venue had to pay someone because another audience member ruined a magic trick. Case 37. The woman who sued an escape room for being too scary, 2017. A woman participated in a horror-themed escape room. The experience was advertised as scary, and participants had to sign waivers acknowledging they might be frightened. During the experience, actors in costume jumped out and scared participants as part of the game. The woman had a panic attack and later sued for emotional distress. She argued that even though she signed a waiver, the experience was unreasonably frightening and that the escape room company was negligent. She won a settlement. An escape room that advertised itself as scary had to pay someone for successfully scaring them. Case 38. The man who sued a golf ball manufacturer. 2001. A man was playing golf and hit a ball that struck a tree, bounced back, and hit him in the groin, causing serious injury. Instead of accepting that he hit a bad shot, he sued the golf ball manufacturer. His argument was that the ball was too bouncy and that the manufacturer should have warned users that the balls could ricochet dangerously. The manufacturer argued that golf balls are supposed to be bouncy and that hitting objects is a known risk of golf. The man won a settlement. A golf ball company paid money because their golf balls bounced the way golf balls are supposed to bounce. Case 39. The woman who sued a movie theater for showing trailers, 2014. A woman bought a movie ticket for a specific showtime. She arrived on time, but before the movie started, the theater showed 20 minutes of trailers and advertisements. She felt this was deceptive because the advertised showtime wasn't when the actual movie started. She sued for false advertising. The court agreed that advertising a showtime should mean when the feature film begins, not when the trailers start. The theater had to change how they communicated showtimes and paid her a small settlement. Movie theaters now often specify that the listed time is when the program begins, not the feature film, thanks to this case. Case 40. The man who sued a theme park for wet rides, 1998. A man went on a water ride at a theme park. The ride was called something like Splash Mountain and had pictures of people getting soaked in all the advertising. The man rode it, got wet exactly as expected, and then sued the theme park. His claim was that he didn't realize he would get that wet and that the park should have provided more explicit warnings. He also claimed that getting wet ruined his day because he had to walk around in wet clothes. Somehow he won a small settlement. A theme park paid someone for getting wet on a ride that was specifically designed to get people wet and was clearly advertised as doing so. Case 41. The woman who sued a gym for being too fit, 2009. A woman joined a gym and hired a personal trainer. The trainer designed a workout program for her and pushed her to achieve her fitness goals. She lost weight, gained muscle, and got in great shape. Then she sued the gym and the trainer for emotional distress. Her claim was that achieving such dramatic physical results made her obsessed with her appearance and working out. She argued that the trainer had been too effective and had created an unhealthy relationship with fitness. She claimed the gym was responsible for not recognizing that she was becoming obsessive. The gym settled out of court for an undisclosed amount rather than fight the case. So a gym had to pay someone for successfully helping them get fit. Case 42. The man who sued a casino for letting him gamble, 2011. A man with a known gambling addiction went to a casino. He had previously been on a self-exclusion list, meaning he had voluntarily banned himself from the casino and asked them not to let him in. Security failed to recognize him, and he entered the casino. He gambled and lost over $100,000. He then sued the casino for negligence, arguing that they should have prevented him from entering, and that by allowing him in, they enabled his addiction and were responsible for his losses. The casino argued that he was an adult who made his own choices. The court sided with the gambler. They ruled that the casino had a duty to enforce the self-exclusion program and that by failing to do so, they were partially liable for his losses. He was awarded significant damages. A casino had to pay a gambler for his gambling losses because their security didn't stop him from gambling. Case 43. The woman who sued a haunted attraction 2015. A woman bought tickets to a haunted house attraction around Halloween. The attraction was marketed as extremely scary with warnings that it included physical contact, intense scares, and was not suitable for people with heart conditions or anxiety. She signed a waiver, she went through the attraction, got scared exactly as promised, and then sued for assault and emotional distress. She claimed that the actors had touched her inappropriately and that the scares were too intense. The haunted house had video footage showing that all contact was appropriate and part of the standard experience that every guest went through. Despite this, she won a settlement. The attraction paid her to avoid negative publicity and a long court battle. Case 44. The man who sued a library for being too quiet, 2012. A man frequented his local library to study. He complained that the library was too quiet and that the silence made him uncomfortable and anxious. He demanded the library play background music or allow people to talk at normal volumes. When the library refused to change their quiet policy, he sued for discrimination. His argument was that the quiet environment was hostile to people with certain sensory issues, and that the library should accommodate different needs. The court actually ruled partially in his favor, finding that public libraries should provide some areas where quiet rules are relaxed. The library had to create a designated area where talking was allowed and pay him a small amount for his trouble. Case 45. The woman who sued over free samples 2013. A woman was shopping at a warehouse store that offers free food samples. She ate a sample, didn't like the taste, and spit it out. She claimed the sample made her sick and sued the store for providing unsafe food. The store provided documentation that the food was fresh, properly stored, and that hundreds of other customers had eaten samples from the same batch without issues. She insisted she had gotten food poisoning. Medical records showed she had a minor upset stomach, but nothing serious. She still won a settlement because the store wanted to avoid bad publicity about food safety. So what do all these cases tell us? They reveal something pretty crazy about how the legal system works. Once you start looking at lawsuits that succeeded despite being completely ridiculous, you realize that the line between reasonable and absurd is way blurrier than you'd think. Some of these cases actually made sense when you looked at the details. The McDonald's coffee case wasn't really about coffee being hot. It was about a company ignoring hundreds of complaints and serving coffee at dangerous temperatures. The unwanted birthday party case was about disability discrimination, not just about someone being annoyed at a party. But then you have cases where someone sued because a magic trick was spoiled, or because they got wet on a water ride, or because a gym helped them get too fit. And those cases won money too. The problem is that the legal system has to take every case seriously to some degree. Judges can't just dismiss cases because they sound stupid. There has to be a process. And during that process, defendants often choose to settle rather than spend time and money fighting, even when the lawsuit is bonkers. This creates a system where filing an absurd lawsuit can actually be profitable. You might not win at trial, but there's a good chance the defendant will pay you something just to go away. And that encourages more ridiculous lawsuits. It's a cycle that feeds itself. These 50 cases represent just a tiny fraction of the weird lawsuits that happen every year. For every case on this list, there are dozens more that are equally bizarre. Some get dismissed immediately, some drag on for years, and some, like the ones we've talked about today, somehow result in the person filing the lawsuit actually winning money or forcing changes in policy. The legal system is designed to protect people and provide remedies for genuine harm. That's a good thing. But it also creates opportunities for people to exploit that system with claims that would make no sense outside of a courtroom. Whether these lawsuits represent justice being served or the system being abused depends on your perspective and the specific case. What's undeniable is that truth really is stranger than fiction, and sometimes the most unbelievable outcomes are the ones that actually happen. The next time someone tells you they're going to sue over something ridiculous, don't assume they can't win. Because based on legal history, pretty much anything is possible. If you want to see more crazy legal cases, check out the next video.